Washington mornings on the Mall. 105.9 FM. And AM 630. WMAL.
6:06, you're on WMAL with Brian and Brian. This is the place where Washington comes to talk. And, of course, we've been talking a lot the last few days about the Supreme Court arguments regarding Obamacare, whether it is constitutional, whether or not the law might be struck down. Someone who's been very active in this debate is Dr. BETSY MCCAUGHEY. She's former lieutenant governor of the state of New York, and she's also been very active in this discussion. She joins us now on the phone. Dr. McCoy, thanks for joining us.
Well, thank you, and the sparks have been flying in the Supreme Court this week, and it looks as if there may be a majority to vote down the individual mandate, the compulsory insurance provision of this law.
Yeah, you know, we have been talking about some of the commentary and some of the reporting, and there is a lot of commentary that suggests that the Supreme Court, especially the conservatives from the Supreme Court who are the majority, have real skepticism about the viability of this law.
That's right, but let me make a point. I've gone over these oral argument transcripts very carefully. If the High Court does uphold the mandate, the ruling will be based on a lie, and here's what I mean. The Obama lawyers argue that all Americans consume health care, therefore they're engaged in health care commerce, so Congress can use its commerce power to force them to buy insurance. But that premise that all Americans consume health care is false. Half of Americans under age 65, the group the mandate applies to, consume virtually no health care year after year. They don't get sick, according to the federal data. All older people need health care, but they're not part of this mandate. They're in Medicaid. And yet no one in the courtroom challenged the administration's false claim, which they made again and again, that this is just a matter of timing. Do you pay for your health care when you get it, or do you pay ahead of time with insurance? A point that Kagan made numerous times, and no one challenged that fact.
Well, their argument is that you're going to need health care at least sometime in your life, certainly when you're born and certainly when you die.
But the fact is the mandate doesn't apply to people later in their life. Everyone's in Medicare at that point and forced to pay for that system. This mandate applies only to people under age 65.
Right. Well, I understand your point, but I mean, isn't it, anyway, it's determined about the 10th Amendment and the Commerce Clause, which talks about the federal government's ability to regulate commerce through the state, but not through the individual. I mean, isn't that the crux of the argument, though, more than anything else?
No, it really is not. The Commerce Clause applies to individuals, not to states.
But I thought that Anthony Kennedy had the best question. He sort of really got to the real nut of the issue. Can you create commerce in order to regulate it?
Well, exactly, and that is the point. If people are not consuming health care, if they're not health care consumers because they're healthy year after year, can you compel them to go into that marketplace and buy health insurance? That is the essence of Kennedy's question.
All right, I know it's kind of off subject then. Because a caller brought this up yesterday and was getting on me on that. Then when Justice Scalia says that, can you regulate broccoli? Well, everybody does consume food. So could then, under the Commerce Clause, could Congress pass a law that says you have to eat a certain food or you have to buy a certain food?
Well, that's right, and the government's lawyers really fumbled on that question over and over again, as they had at the appeals court level. They couldn't identify what made health care different. After all, if government can force you to buy health insurance, they could force you to buy GM cars to prop up Detroit or stocks and bonds to prop up Wall Street.
Yeah, but not everybody is in the car market, but everybody is in the food market. So I'm asking him, is Scalia's argument about broccoli, from what you're saying, it seems to me like then, if Congress is dumb enough to pass a bill, that would be constitutional because everybody is in the food market.
That's right, but that's very much to the point again, because not everybody is in the healthcare market.
Okay, so that's where the bottom line is not everybody is in the healthcare market, and therefore it's too far.
I'm okay with broccoli. Just don't bring any Brussels sprouts, okay?
Yesterday's argument was even more interesting.
Well, that's what I was going to ask you about, the severability thing.
That's right. There was intense interest in severability, and all of the justices were saying to the lawyers, give us a principle. Scalia said, I don't want to wade through this 2,572-page law. That would be cruel and unusual punishment. He cited the Eighth Amendment. Kennedy said, why should we have to pick through this extensive law and decide what stands and what falls like a house of cards? The whole thing should fall. Give Congress a blank slate to solve the health care problem. But on the other side, Sotomayor And Ginsburg said, wait a second, there are many things in this law that don't pertain to the individual mandate. They were arguing to save part of the president's signature legislation.
Right. But then you get the high court acting as legislators.
Well, Kennedy's question was the most interesting on that point. He said, are we acting as legislators when we pick and choose what to strike down? These provisions are so interconnected. Or are we acting as judges by saying we don't have the expertise to decide what will work and what won't work?
It's not their job to write the law, it's their job to interpret whether the law is constitutional.
Exactly, but if they strike down the mandate without striking down other parts of the law, will that spell the death of insurance companies that are forced to take people with pre-existing conditions and the healthy people won't sign up?
Right, but...
That's exactly what he asked.
Yeah, but and the only remedy to that would be for Congress either to immediately pass a law that says that portion for insurance companies is repealed, or for the insurance companies to sue and go to court.
Exactly, and they discussed that option, but then Kennedy also said, we could apply the standard, would Congress have passed this law without the mandate? He said, but let's face it, Congress wouldn't have passed any of this. In order to get 60 votes to get this squeaker through, they had to have things like the Cornhusker kickback. Obviously, you take anything out of this law, and the rest would not have passed.
Right. When it comes to constitutionality, though, if only the mandate is unconstitutional and the other parts are not unconstitutional, I mean, it goes back to what power should the courts have? Should they be able to decide that the whole thing is the whole bill has to go because only one part is unconstitutional? If other parts are legal, then should it be the court's decision to throw out the entire thing?
Well, let me throw another wrench in the works. Of course, they also discussed yesterday whether the Medicaid expansion was constitutional.
Yes, right.
And if that is struck down, how could the rest of the law possibly work? Because the way that the president covers almost everyone is not with private insurance. It's this vast expansion of Medicaid. Only 3% more people will have private insurance under this law than without it, according to the administration's numbers. But 30% of Americans will be on Medicaid.
I got to ask you very quickly about this idea about severability. I mean, this is a very, very well-established precept of the law.
Yes,
every contract has a severability clause in it, doesn't it? I mean, almost any contract that you sign has a severability clause in it.
But the Congress deliberately took it out. It was in the House version. They removed it from the Senate version because the authors of the law said this law won't work without compulsion.
Now, if this thing passes, let's say the Supreme Court rules that the individual mandate is unconstitutional, but doesn't strike down other parts of the bill, does that make things actually worse?
No, but Congress will have to actually do its job, read the law they passed, and then identify which parts they need to excise. And at that point, let me just mention, I have a new book out today, Decoding the Obama Health Law. No spin, plain English, walk through the law, and maybe the justices will find it handy.
Right.
All right.
Thank you,
Save them having to go through the 27,000 pages.
That's right.
Dr. McCoy, it's always a pleasure to have you on. Thanks so much.